Hello, and welcome to this edition of the New York State Science and Technology Law Center webcast. I'm Joel Whitney with the Syracuse University College of Law, and it's my pleasure to introduce to you the host of today's webinar, Shubha Ghosh, the Crandall Melvin Professor of Law and Director of the Technology Commercialization Law Program. Shubha?
Yes, thank you, Joel, and welcome. Today we're not going live, so this is a recorded broadcast or webcast and available on our YouTube channel. And I wanted to get this out quickly because the U.S. Supreme Court had an interesting pair of arguments on Monday of this week, on November 27th, in the area of patents. So the title for today's webcast is Patent Doubleheader, Supreme Court Takes on the USPTO. And so I'd like to present the two oral arguments, give some background on the cases, give some predictions. And even though we're not live, we can't have a live discussion, but I hope this generates some interest among viewers. For those who want to follow along with the slides or have a copy of the slides and are watching this on YouTube, they should be available on the link below. So what was this doubleheader about? It basically involved two cases. The first one was well-watched, Oil States Energy Services versus Greene's Energy Group. And this is the more fundamental one because it's basically asking whether a particular provision or set of provisions within the American Invents Act is constitutional. So it's got a lot of people chiming in about the proper procedures for the U.S. Patent and Trademark Office, when can an administrative agency review patents and even to a certain extent, find them invalid, though we'll see what the right nomenclature is for what the PTAB or the Patent Trial and Appellate Board is doing. And so this one has gotten a lot of attention, at least among patent circles, but certainly in the press more broadly, because this is a review by the U.S. Supreme Court of a particular aspect of a large administrative agency. So it raises some interesting government issues as well as political issues about the relationship between the courts and the legislature, between the legislature and the executive, and then what role the courts have in policing those boundaries. The second case has gotten a little bit less attention. As we'll see, it's more of a technical question. It's SAS Institute Inc. versus Matal. And it has, again, to do with inter partes review. The issue there is whether the PTAB, the Patent Trial and Appeal Board, must review all patent claims in an IPR. So just as in the Oil States Energy Services case, the SAS Institute case also implicates this inter partes review proceeding. And even though that's the particular proceeding that's at issue in these pair of litigations, it also has implications for other review proceedings, such as post-grant review or PGR and covered business methods. And so I'll try to give a little bit of background to all of those, but my primary focus is on inter partes reviews, because that is what the court is looking at. And if the court does take a very broad approach to say, for example, that inter partes reviews are unconstitutional, then very logically that should extend to these other review proceedings as well. Okay, so let's talk about these two cases and provide some backgrounds. Oil States Energy Services, first of all, the patented issue is a method to reduce pressure on and damage to wellheads during hydraulic fracking. The procedural context is that Oil States sued Greene for patent infringement. Greene initiated an IPR after the Markman hearing. So the patent lawsuit had proceeded quite far, to a point where there was some construction of the claims by the court. That's the Markman hearing. And then Greene, in response to that Markman hearing, initiated the IPR to challenge the validity of Oil States' patent. Now, the board found two of the claims invalid, and this gets to the heart of Oil States' infringement claims against Greene. And so Oil States appealed the decision of the board to the Federal Circuit, that affirmed without opinion. And I want to emphasize that without opinion, that was also a controversial aspect of this case, that the Federal Circuit does issue orders without giving a formal opinion. It certainly has the power to do that, but it's been a source of controversy for practitioners because we have no idea why the Federal Circuit affirmed, just that it did affirm. It seemed to suggest that this was just a routine matter, and therefore there were no special issues that had to be justified or explored in an opinion. So once the Federal Circuit affirmed, then you have all states doing this appeal, the grant of cert by the Supreme Court on this particular case, and we've got Supreme Court review, which is the subject matter for today. So what is an IPR? An IPR, or inter partes review, is an administrative proceeding created under the American Invents Act that went into effect in 2012. It allows a third party to challenge the validity of a granted patent on novelty and non-obviousness grounds. And so it cannot be on other grounds other than 102 or 103 of the Patent Act. And so the bases are largely a new prior art that the third party has discovered and thinks it's relevant for the Patent Trial and Appeal Board to review, assessing whether the USPTO granted the patent correctly. So just to understand the scenario, an inventor or his company has applied for a patent, the USPTO has granted the patent, and once the patent is issued, then the patent can be challenged by third parties. And so this is sometimes referred to as a post-grant opposition or some sort of post-grant proceeding, and that might be relevant for the theory that Oil States is propounding here. So an IPR is initiated through a petition with the Patent Trial and Appeals Board, that's the PTAB, who decides whether to institute the challenge. So the first threshold that the petitioner has to go through, the petitioner here for the PTAB is Greene, because that's the company that was challenging the validity of the patent. The first hurdle it faced was this institution. Does the PTAB think there's some reasonable basis for pursuing these challenges, or is the prior art not relevant, or the prior art does not seem to really challenge the validity of the patent? There is this threshold institutional requirement. And then once it gets instituted, as we'll see, and this becomes the issue in the SAS case, the PTAB then can review the relevant claims. Now, one of the reasons to spend some time talking about this institution is that the institution decision is not appealable. So that once the PTAB decides not to institute on certain claims or on any claims, then that's not appealable. Congress made the decision to sort of streamline the process. It did not want to have a series of interlocutory reviews, the appellate process being used strategically to hold up the review of the validity under the IPR. And so this was the subject of a previous Supreme Court case, this question about this institution decision not appealable. The Supreme Court, I should note, did uphold that aspect of the statute. It did not address, of course, the broader questions that are at issue in oil states because they were not before the court. And so this issue about non-appealability was affirmed in Quozo Speed Technologies versus Lee. So this is from last year, or I think about 2 terms ago, actually. And we do have a separate webinar that I gave right after the Quozo decision in spring of 2016, and we can provide a link to that webinar as well as to this decision if people are not familiar with it on the link below. So that's important background about this, and this issue about institution is going to come up again in the SAS case in some detail, so it's worth flagging here. Now, the PTAB can rule that the granted patents are unpatentable. It will look at the prior art that's been submitted by the third party and then see whether, in fact, the new prior art that the third party has introduced does, in fact, make the patent unpatentable because it's not, in fact, novel or not, in fact, non-obvious. So then the appeal of the final PTAB ruling goes directly to the Federal Circuit, and that's also an interesting aspect of this. It got a little bit of attention in the oral argument, but it has gotten a lot more attention among commentators because there is no appeal to the district court. It has to go to the Federal Circuit. And one of the issues in this case, as we'll see, is whether this proceeding requires some scrutiny by an Article III court. The PTAB is not an Article III court. It is an administrative court within the U.S. Patent and Trademark Office, and it is making a decision about patentability. And so the question among some, such as Allstate, is whether that is constitutional, because there is no review by a Article 3 court, except for this appeal to the Federal Circuit, which of course is reviewing the matter for questions of law and procedure, rather than giving some sort of a full review, as a district court might do, to this question of patentability. And so this is, the last bullet point here in some ways might reflect some of the controversies over this proceeding. Administrative court, PTAB, and seems to be some, but maybe not the full review by an Article 3 court that we need when we're dealing with federal rights such as patents. So let's talk about the legal question. As I mentioned, the legal question can be summed up succinctly as follows. Can an administrative agency like the USPTO, and here the USPTO is working through its court, the PTAB, take away patent rights without violating Article 3 and the Seventh Amendment right to a jury trial? So since this proceeding, the IPR, is occurring largely within the agency, there is no jury trial. It's a panel of Article 1 judges, or administrative law judges within the USPTO, largely former patent examiners, that are making this decision, but there is no jury trial. So there are sort of two separate questions that are hidden in this one question. That the first is one about the need for an Article 3 court to be involved, and to what extent does it have to be involved. And then the second question is this issue of whether there is a violation of the right to a jury trial. And that's part and parcel in some ways related to the first question, because if it was in an Article 3 court, then there would be a separate issue about whether there would be a jury trial right, but there clearly is no jury trial in the PTAB proceeding. And so the failure to bring this in a district court, or allow this proceeding in a district court, might give rise to a separate claim that there is a violation of the Seventh Amendment right to a jury trial. I'll sometimes separate these two issues, but in the oral argument, they were sort of talked about together. It's sort of an all or nothing in some ways, because if an Article 3 court does not have to be involved, or if the proceeding as is adequate to satisfy requirements for review under Article 3, then the Seventh Amendment jury trial issue doesn't arise. So really the Article 3 issue is a threshold issue, even though as a technical matter, the two are, can be separated in terms of some of the legal analysis. So let's talk about the elements of the question then, to take it apart a little bit. Is reviewing the patent grant for error or interference with property rights? So this is part of Oil State's arguments that we'll see. The PTAB, this administrative agency, is looking at a patent that has been granted. So the patent owner does have a property right that's been authorized by the federal government through the USPTO, and is losing that right potentially if the PTAB finds that the underlying invention was unpatentable because of the new prior art that has been introduced. So Oil State is saying this is a taking away of property rights, and interference that requires more due process protections, such as would be provided through an Article 3 court. And the Article 3 court, then the Oil State could, bring some more specific testimony, could have a fuller trial on this matter, rather than having been done, but basically by an administrative hearing. Greene, on the other hand, is saying that there is no real interference with the property right. All the PTAB is doing is correcting a potential mistake. So, you can think about different analogies. You can think about it maybe analogous to a recording of a deed for real property. If that recording was done in error, then there should be some sort of procedure to catch that error. And that is not an interference with property right in the sense of taking away a vested right, but just reviewing that right to make sure that it's been granted correctly. So at some level, there is this conceptual problem as to what is happening with an IPR. Is it a procedure by which property rights are taken away, or is it more of an investigative examination type procedure, just an extension of what the USPTO is doing? Do remember that the USPTO has to review an application before it decides whether to grant the patent, and so the IPR is just an extension of this. So I think we'll get a chance to talk about this a little bit, but I should mention here with respect to question one that before we had the inter partes review a procedure that was implemented in 2012, we did have, in the 1990s, Congress adding other procedures, the two big ones being inter partes re-examination or inter partes examination, and then a re-examination procedure. And Oil State does distinguish those two. Those were not really directly challenged for constitutionality, but they had existed for a long period of time. And so, there is an argument that such a procedure that did exist for a long period of time, if it wasn't unconstitutional, why wasn't that challenged? And so Oil State does distinguish those as being more error correcting. Those are really proceedings that maybe had a bit more process to them. It certainly didn't have this threshold question about institution, at least in the same way that we see with IPR. So those proceedings that existed before the American Invents Act are, to say, distinguishable according to Oil State. But this one, the IPR, certainly does raise more deep questions. And so if you go to the question two, Oil State's view is that there's a question about whether it's constitutional for a non-Article 3 body to cancel patent rights. And so again, the PTAB is not an Article 3 court. The judges don't have life tenure. They don't go through the same vetting process as if you're going to be a district court judge or a federal appellate court judge or a Supreme Court justice for that matter. And so we're dealing with a special body here, and what it's doing is canceling patent rights. And so this raises, Article 3 questions. It raises potential due process questions. You can imagine the situation if any federal claim had to be determined by an administrative agency rather than by a district court. And so, of course, we do have administrative agencies that make determinations about rights. And this has come up. We have the National Labor Relations Board. We have the Federal Communications Commission. We have the Federal Trade Commission. We have numerous agencies that have courts embedded in them, or at least administrative law judges active to review decisions. And so, depending upon how the court comes out, this question could have implications for these other agencies as well. And certainly the court is very concerned about these reverberations and wants to try to minimize them as much as possible. There's also the very important Supreme Court decision, Crowell versus Mooring, from the 1930s, so from the New Deal, when again you had an expansion of administrative agencies, and the issue there arose of creating these administrative courts and whether that violated due process or created problems with Article 3. And in Crowell versus Mooring, very succinctly, the Supreme Court said there was no constitutional problem with creating these courts, unless there was some separate due process violation or some other constitutional infirmity, such, for example, violation of the First Amendment or the Fifth Amendment or the Sixth Amendment and so forth. So we come into this case, into the Oil State case, with these administrative courts across different agencies in place, and a very, as the Chief Justice Roberts might say, a super precedent, Crowell versus Mooring, that says these administrative agencies are constitutional. The question then becomes whether the law the views have changed. So maybe Crowell versus Mooring is no longer good law. Maybe that precedent will be overturned. I think that's unlikely, but I certainly think there are a minority of scholars, at least, and maybe practitioners, who do wonder about the expansion of the administrative state and may view this case as a way to try to limit that expansion in some ways. But I think ultimately this really depends upon the specifics of this administrative court, the PTAB, and how it's operating and what exactly is it doing. Is it really canceling patent rights, or is it just simply making a ruling that the invention is unpatentable based upon new evidence that has come into play? And then that ruling obviously has implications for the enforcement of the patent in courts. And so it's obviously an important finding by the agency, but it may be a little bit strong to say that it's taking away patent rights. It's just simply examining new evidence about patentability and then making a determination about that new evidence. So you can see the tension here. Oil State, that side of the argument, is really concerned that rights are being taken away effectively, even if not in a formal way, while the other side is saying that, no, this is just simply an evidentiary matter, and the agency, the PTAB, is just simply reviewing this new evidence to make some sort of determination. And then, of course, the Federal Circuit can review the decision by the PTAB and make its own determination. Though do keep in mind, in this case and in other cases, the Federal Circuit seems to be, affirming the decision of the PTAB without an opinion, without a written opinion. And so in the background, and this is, of course, something that Oil State pushes on occasion in its oral argument, maybe the Federal Circuit is there to provide some review, but in name only, it largely has been deferring to what the PTAB is doing. And of course, that's an empirical question and part of the controversy here. Okay, so the last issue here, of course, as you mentioned, is can a property right such as a patent be taken away without a jury trial? I don't think the court will spend that much time addressing this last question, because I think it can dispose of this matter on the broader Article 3 issue, rather than getting into whether a jury trial is required under the Seventh Amendment. If a jury trial is required, I'm just trying to show you the logic of this. If a court did go this and say, okay, we think the PTAB proceeding, the IPR, is fine. The only problem is that you need a jury trial if property rights such as a patent are being taken away. The PTAB does not provide a jury trial and does not have the ability to provide a jury trial. Therefore, there has to be some sort of Article 3 proceeding within a district court to satisfy this jury trial right. So hopefully everybody sees where this fits into the argument. I think it'll only come up if the court really is concerned about this proceeding, and if it is otherwise valid or constitutional under Article 3, and there's this then remaining question about the jury trial and how that arises. I can talk a little bit about this. It got some attention in the oral argument, but really not that much. A lot of this oral argument focused on how patents were reviewed in the past and how patent grants were re-examined, and a lot less on whether there would be a jury trial right. Do keep in mind that one of the famous jury trial cases or the right to a jury trial cases in patent law is the Markman versus Westview case, the case that led to the Markman ruling. And in that case, the court said that there was not a right to a jury trial in determining the construction or meaning of a patent claim. And there's a lot of history there that's interesting to see how you had special courts reviewing patents and doing this largely as a matter of law by judges. Now, this is going back to the English history, so it's not under the U.S. Constitution. Article 3 question is obviously irrelevant for those cases. But the English history is relevant for understanding what courts have done in the past and how they've been structured, and whether then, given this history, there is a need for a full Article 3 review, or whether something less combined with some sort of Article 3 appeal would be satisfactory. So a lot of discussion about the history of the courts, and I'll try to get to that in our more detailed discussion in a few minutes. So what were Oil State's arguments here? I think the attorney for all states, Ms. Ho patent attorney from Dallas, I'm blanking on her law firm affiliation right now, did an excellent job. I think a lot of the commentators pointed to how direct and to the point the arguments were. Not that necessarily the arguments themselves are winners, but they were presented in a very clear and very forceful way. And so the arguments basically boil down to this. The first one is that the PTAB does exercise a judicial power. It's adjudicating a dispute among private parties. It exercised this judicial power in a dispute between private parties, here the patent owner and the party challenging the patent. This dispute is over private rights, and so the rights at issue here are the ownership rights in the patent. This exercise of power is without Article 3 supervision and consent. So this has been very different from other matters, for example, using a magistrate judge. Again, a magistrate judge is not an Article 3 judge, but Article 3 judges do rely upon magistrates, but the magistrate is under the supervision, and the magistrate judge is chosen by an Article 3 judge, so that does not create a problem. Here, the judges on the PTAB are selected within the agency. There's no review. There's no Article 3 judge saying, well, this administrative law judge is acting under my supervision. They're largely independent. And that does create some interesting structural problems with Article 3. Again, if you want to try to understand the legal issue, it's always good to think about sort of a slippery slope argument. What if all administrative agencies then had matters adjudicated fully by administrative law judges? Then what is the point of having Article 3 judges? Does this really undermine the structure if we allow this to go too far? And so the question then is, and of course all states making the argument, that with the PTAB, it does go too far in terms of circumventing Article 3 supervision and consent. And then finally, the last linchpin to the argument is a historical one. The issues that are reviewed by the PTAB as to patentability have been adjudicated by courts for over 400 years. So obviously the 400 years here include the English history that I've been talking about. And so you'll see mention in the oral argument and in some of the briefs, and I think very likely in the final opinion, something called the Privy Council. So this was a court that basically would review patents and would review other matters relevant to parliamentary statutes. And the Privy Council itself was a court. And before we had the establishments of the courts in the U.S. And once you did have the establishments of the courts in the U.S. through Article 3, you did have the courts, the district courts, then reviewing patents. Often that review would arise as a defense to patent infringement. The alleged infringer would raise in the court the invalidity of the patent and would bring in evidence very similar to the kind of evidence that might go to the PTAB now. And alternatively, the district court and the Article 3 court would be able to review validity through something called a declaratory judgment, where a party would be able to, a party with appropriate standing would be able to raise evidence about invalidity of the patent. So very briefly, that's 400 years of history, admittedly not presented all that elegantly, but the point is courts have been looking at this. In the 1990s, you've had these administrative proceedings that were introduced, the re-examination and the inter partes examination. Those were different, even Allstate concedes that those are different because there was some appeal to Article 3 courts. And the scope of that and the timing and the procedures were quite a bit different than the PTAB. The concern here is that the PTAB is making decisions about patent validity, and even though they can be reviewed by the Federal Circuit may be doing that fairly perfunctorily. Looked at another way, Congress created the PTAB to streamline the process to make sure that patents were granted validly. But by streamlining the process, oil states essentially arguing that it's also short-circuiting the process in protecting the rights of patent owners. So one of the arguments on the other side in support of the IPR, the arguments by Greene and also by the government, they again boil down to three. The IPRs review the grant of the patent entrusted by Congress to the executive branch in 1790 and is not an inherently judicial process. So they're pointing out that the initial grant of the patent is done by the USPTO. We've not always had examinations, but the first Patent Act did have examinations, and then there was a period of about 30 to 40 years where there was no examination. We had more of a registration-like system for patents. But then since the 1830s, we've developed more of an examination system that's given rise to the type of elaborate examinations that we have now by the USPTO. The USPTO is in the Department of Commerce, so it's an executive agency. And so we've had this issue of the granting of patents going to the executive branch. And so it's not an inherently judicial process whether a patent should be granted or not. And so the idea again here is that the IPR and these other proceedings, such as the PGR and the covered business method patents, the CBM, are really just extensions of the examination process, or the prosecution process as it's more formally known, by the USPTO, and therefore there's nothing inherently judicial in this decision about whether to grant a patent or not initially. So it's very different than just simply private adjudication over a violation of rights. It's really a question what's going on with the IPR, according to Greene and the government. It's just simply this review of whether a patent should be granted, and that's been done by the executive branch, the executive agency here, the USPTO, in its various incarnations since 1790. 1790, of course, being the year in which the first Patent Act was enacted. So I think that's a fairly interesting, very intricate argument. The second argument is that an IPR does not extinguish private property rights. And so there are many elements to this, some of which we've talked about, that it's not so much extinguishing the right, but just simply coming up with some sort of evidentiary ruling whether the patent was valid or not, whether the invention was patentable. And so there's that aspect about extinguishing. It's technically not extinguishing, it's just finding new evidence. And evidence, if the patent, what the new evidence is basically trying to show is that the property right should not have been granted in the first place. And so that's not extinguishing so much as correcting error that might have arisen. The other aspect of this argument is the word private. This did not come up as much. There's one mention of it in the oral argument, maybe one or two mentions of it. And that has to do with what the nature of a patent is. Is it really just a pure private property right? Or does it have some aspects of public property to it? Remember, the idea of the patent is that you have an inventor that has come up with something that's new and non-obvious and useful and that can be specified. And the inventor files an application with the patent office. If the patent office grants the patent, then the inventor gets these property rights for a specific period of time, just to keep it simple, 20 years. And then once those 20 years are done, then the invention is in the public domain and anybody is free to use it. So this is a very interesting question as to what the right is in. We often talk about the patent as a property right, but technically we're thinking about the property right as being in the invention and the property right lasting for a limited period of time. And then once that time is expired, the invention goes to the public. So even though a patent is something that is owned by a private party, really what the patent is representing is a property right in the novel, non-obvious, etc. invention, which again, the patent owner is sort of holding for a particular period of time before it does go to the public domain. So if you look at the structure of patenting, it's very different than, for example, ownership in land or ownership in personal property. Of course, you can have various types of estates in land as well as various types of property rights with respect to personal property. But the underlying nature of the right for those is something called a fee simple. They last forever. And so there's no question about the land or the personal property going to the public under the basic common law notions of what the property right is. Patents, however, are very different because of this structure. And so for the second argument, the two parts of this is having to do with the word extinguish, and the second part having to do with whether this is really a private property right in the same way. So I don't think people are conceding that, for example, that the government can just take away somebody's land and say you no longer own this land without providing the adequate process. Obviously, there's eminent domain, but many practitioners, many people listening to this know that eminent domain has its processes, and that can involve both state courts and federal courts. Even though there might be an administrative body at the threshold making a determination, there are these elaborate processes that arise there. Oil State is saying that IPR should be held up to that same standard. Greene is saying, no, IPRs are different from that because of both whether it does in fact extinguish, and secondly, whether in fact we do have a traditional private property right. So this then gets to this broader question that has come up. It has come up largely in terms of the parallels with these issues that arose in the bankruptcy law context. And so one strong argument is that the patent rights involve public rights. And this is not simply because the invention goes into the public domain once the patent expires. It's basically saying that the patent is granted for the benefit of the public. The patent is granted initially not just to inure to the benefit of an inventor or its company, but it's meant to promote progress in science and the useful art. So again, that's very different from land, where somebody may have acquired a piece of property through conquest or through acquisition, some other type of appropriation. There's some private act by which the property right is created in land, but there's not necessarily any public benefit. It's not basically done for the public, except for the very broad sense that having a system of private property rights benefits the public. But the whole idea behind granting the patent rights in inventions is solely to benefit the public. Remember, we don't give patent rights to any invention. We only give patent rights to ones that have some novelty or non-obviousness associated with it, that are useful. And those are all measured in terms of some public criteria. In other words, does the public already know the invention, that it's not novel? Is this something that would be inventive or some sort of a step forward in the evolution of a field or the evolution of a technology? Again, that's sort of a public notion about whether this invention is non-obvious. And then finally, utility is really asking about what the application is, and in the back of that is some notion of how is the public benefiting from this invention. So this has not gone that far. It comes up largely because of parallels, this third argument, and hopefully people see how it's different than the second argument. The second argument is just basically saying that this is different, that patent is different from other types of private property rights. The third argument is saying that patent rights are really public rights and not private property rights at all, or maybe only nominally they are. And so the reason why that third argument is there is because there is a line of cases that come out of bankruptcy to basically say that the role of Article 3 judges and the role of administrative agencies are different when we're talking about pure private rights than when we're talking about public rights. And this came up in the bankruptcy context because a bankruptcy court, and I'll just talk about that in the abstract now, even though the bankruptcy court is a very complicated creature of law. But a bankruptcy court adjudicates all sorts of rights. In terms of trying to settle a debtor's claims, it has to look at private rights. It has to look at some public rights. It has to look at the rights of all the creditors and so forth, and sort those out. And so the issue then about public rights versus private rights comes up in terms of how the bankruptcy courts and the bankruptcy proceedings are set up. And so the Supreme Court generally has been very skeptical about those cases, or at least some justices have, and Justice Roberts expressed his skepticism about a case called Shore regarding this private versus public right aspect. And so just judging from the oral argument, even though this got some press in the briefs and in public discussion of the Allstate case, I'm not sure the court is going to go there. I don't think it's going to go back and use this case to overrule some of its bankruptcy precedent, though there might be some implications for those cases. I mean, I think it really is going to just focus on the PTAB and the IPR within the patent context and really try to get a handle of what exactly is the PTAB doing. Is it, in fact, extinguishing a private property right, as Allstate is contending, or is the IPR just correcting a mistake through the PTAB as an administrative agency that the USPTO made because it did not have the full prior art, or the prior art wasn't accessible, and so forth. So, excuse me. And so that's sort of an open question then about how it's going to be characterized. And my sense is that the court rules on that question about how characterized the IPR, the PTAB is doing, rather than getting into this sort of deeper question, if you will, about whether the public right or private right. So let's do a quick assessment, and then I'll do a prediction, and then we'll look up the case way. So, assessment. The court has been deferential to Congress on IP issues in most cases, regarding the extension of the copyright term, regarding matters involving, think about the Quozo case just from last year, regarding the institution of an IPR. So on this matter, the courts don't want to second-guess Congress on intellectual property issues. Article 1, Section 8, Clause 8 really gives Congress the power to promote progress, and the court has been deferential to Congress's judgment about the best way to do that, and does not want to sort of implicate its own views about what patent law or copyright law should be. But the court has been concerned about limits on judicial power. So whenever its power comes into play, and I don't mean the Supreme Court's power, I mean the power of federal courts, it's been less deferential. It's been, provided some more scrutiny. So on questions about certain defenses like latches and statutes of limitations, it's looked at this question about what's the relationship between the statute of limitations in the Copyright or Patent Act and latches, which is an equitable limitation on claims. So when its own power comes into play, another example would be the Markman case regarding the right to a jury trial for claim construction. The court has been less deferential in the sense of not that Congress loses, but it does provide some more scrutiny, and it might do so here, even though my sense is, at least judging from Quozo, and the composition of the court has not really changed except for Justice Gorsuch since last year. I don't see some sort of bellwether change in how the court is going to view Congress on these matters. Now, the historical evidence about patent litigation and Privy Council is not strongly supportive of petitioners' arguments. So the petitioner is making an argument that these are decisions made by the courts and so forth, and that's been going on for 400 years and so on. But you've had revocations of patents that have occurred by the legislature. You've had revocations of patents that may even that occurred with the executive branch, and so those have not involved necessarily Article 3 review. So, for example, if an invention implicates national security, then the executive branch and the legislative branch can intervene to sort of make sure that that invention is not disseminated, and that can entail some limitation or complete limitation or exclusion from patenting. So again, historical evidence not clear. Constitutional text is not persuasive. I mean, Article 3 does lay out the original and appellate jurisdiction of the federal courts, and keep in mind that Congress does not necessarily have to create these federal courts, except for the Supreme Court on these matters. And so there's kind of an interesting Article 3 question, a textual question about whether a PTAB would violate the Constitution. I don't think the text is particularly persuasive. Here, a lot of this rests upon structural arguments about the relationships between administrative agencies and the courts, and specifically how you administer patents and the decision to grant patent rights. And I think the structural arguments would weigh in favor of the respondent. So you need efficient review of patent grant. I mean, that's the whole idea behind the PTAB, rather than having it be done in courts. So if you didn't have these administrative proceedings, the way it would work is you'd have patents out there. Some of them may be valid. Some of them should not have been granted. Then a patent is the basis for litigation. And then in litigation, the defendant would challenge the validity of the patent. And that can be a woefully inefficient system in the sense that you have these invalid patents that are out there potentially causing problems, because many of these cases do settle. So you can have licensing and settlement agreements that are based upon invalid patents. And so the idea here is to have some efficient review of the patent grant once it's been granted, so that we make sure that the patent has been granted correctly. Now notice, we could have a system where the review is not after the patent has been granted, but before the patent has been granted. So, for example, in trademarks, there are ways to challenge the registration of a trademark after it's been registered, but the whole trademark registration process involves something called an opposition, which is a pre-grant proceeding, where the trademark office, that part of the USPTO, will publish a trademark application and allow people to raise oppositions to it before the trademark has been registered or granted, so to speak. So one of the things that's fairly interesting, I've always found this kind of puzzling, that if this were done, if the IPR were done as a pre-grant proceedings, most of these arguments would go away. That seems like a very easy fix. In some ways, it's easy technically. Obviously, politically, it may not be that easy to do. And it may not be all that easy to implement because in many situations, a patent owner may not want the invention to be published before the patent is granted, even though we have requirements now that certain inventions are published, that certain applications are published before the grant of the patent. Putting all those technicalities aside, I realize those exist. It is interesting that if this were a pre-grant review, then from a structural point of view, these arguments just go away, which has to make you wonder about the strengths of the post-grant. Now, obviously, simple changes can have whirlwind effects as far as constitutionality. But if the court does go so far to say that these types of post-grant review proceedings are unconstitutional, then I've just kind of told Congress what it has to do if it wants to revive them, make them pre-grant as we have for trademark. The other aspect of this, of course, is independent of this streamlining of review, the patent applicant is aware of the rules. So from a property rights perspective, you know that you might lose the grant if new evidence comes in later. And that's true for lots of things. You might buy a car, it turns out the car was stolen, because the car was stolen, you might lose your rights in the car. That doesn't mean you lose any legal claims. You might be able to get your money back, or you might have other claims against the person who sold you the car and so forth. But you do lose your car if it turns out to be stolen in most situations. But you're aware of those rules. You wouldn't necessarily say that when the government or the court takes away your car, then you've lost a property right because you're aware of the rules about stolen property. Same thing here. If a patent applicant knows what is required to get a patent, and they also know that it's possible that new evidence can arise later, then it's really hard to say that they've lost, or to use the strong language, that their private property rights have been extinguished in anything but a technical sense. I don't want to suggest that all property rights can be taken away at a snap of the finger, as an ipsit dixit, or one of the terms that came up in the oral argument was bitter and the sweet. So the sweet of having these grants or having property comes with the bitter that can be taken away. And of course, there have to be proceedings that do this. And needless to say, the one issue in this case is whether the PTAB proceeding is adequate enough. But nonetheless, if you look at how broad some of Oil State's arguments are, they seem to overlook the fact that the patent applicant knows the rules going into the game, and that the patent grant might be found to have been improperly granted. I also mentioned Kroll versus Mooring, precedent administrative process. I don't think the court is going to overrule Kroll versus Mooring, and there might be one or two justices who want to do that, but I don't think you have certainly 5 justices who want to do that. And so you do have this precedent that administrative processes are okay under Article 3 as a general matter, but it'll be interesting to see how the court addresses this issue and finds in this particular administrative. And then I also mentioned the bankruptcy court cases. Those did come up in some of the briefs and in some of the commentary. I think this is different from Marathon Pipeline case in 1978, which did find that the Bankruptcy Act that was revised by Congress in the 1970s and the bankruptcy courts that Congress had created were unconstitutional. But those are really different, I think, because the bankruptcy courts were given a lot more independence. They were not necessarily given the same kind of autonomy that you might see for an Article 3 judge. And they were largely established so that you didn't have that kind of supervision. There might be an issue here about whether appeal to the federal circuit rather than to a district court provides adequate supervision. That didn't come up as much in the oral arguments. There is this nagging question about whether the federal circuit is, hate to be so blunt, is doing its job when it's just simply issuing orders without written opinions under Rule 30. There have been, some commentators who've taken the federal circuit to task on that. And so, that might be a separate issue worthy of another litigation. I don't know if the court's definitely necessarily going to rule the PTAB unconstitutional because of what the federal circuit is doing. Okay, so these are my assessments. Quick prediction: court will most likely affirm. Think again about the practical effects of not affirming. In other words, finding that the PTAB is unconstitutional. There are no strong arguments to rule a federal statute unconstitutional, really. I mean, they're interesting arguments, but I don't think there's really a slam dunk argument that Oil State has come up with. And so, as I mentioned again, if the statute is struck down, the pre-grant procedures would most likely address the concerns. So a quick fix. Let's then quickly talk about SAS versus Matal in the next 10 minutes or so. The patented issue was one that was granted to Complement Soft, who had sued SAS for infringement of covering a system and method for generating software code. And so the procedural context is that after the infringement suit had been initiated, SAS petitioned for an IPR challenging the validity of all 16 claims in the patent. And now this is where the institution aspect that was affirmed in Quozo comes into play. The PTAB instituted as to 9 claims and issued a ruling on these claims alone. SAS argued that the PTAB had to reach a ruling under all claims in the petition, but the Federal Circuit again just affirmed the PTAB, though it did here in this case with a written opinion. It didn't just simply affirm without an opinion. And then SAS appeals to the Supreme Court. So the legal question, lots of verbiage here. A lot of it has, the reason why this language is so long, the question is so long, is because it does involve statutory interpretation. And so the legal question is whether 35 U.S.C. Section 318A, which provides that the Patent Trial and Appeal Board, in an inter partes review, and this is now quoting from the statute, shall issue a final written decision with respect to the patentability of any patent claim challenged by the petitioner, requires that board to issue a final written decision as to every claim challenged by the petitioner, or whether it allows that board to issue a final written decision with respect to the patentability of only some of the patent claims challenged by the petitioner, as the U.S. Court of Appeals for the Federal Circuit held. So this is kind of a boring case, to be blunt. I mean, it really has to do with how you interpret the statutory language. It really boils down to how you interpret the word any. Does any mean every, which is what SAS is arguing, or does any potentially just simply mean some of the claims? So if you look at the statutory text, I've quoted the thing of the language from 318A, patentability of any patent claim. Under 314A, which has to do with institutions of IPRs, an IPR is instituted if there's a reasonable likelihood that the petitioner would prevail with respect to at least one of the claims challenged in the petition. To at least one of the claims challenged in the petition. And so SAS is arguing is that the word any in 318 is referring to the claims challenged in the petition under 314A, while the government is arguing, and Matal here, remember, is the interim director of the USPTO, but the government is arguing that it really only applies to whatever claims were instituted by the PTAB. So the Federal Circuit basically says that the claims in 318A are different from those in 314A, and we'll kind of elaborate on that argument next. As I said, there's an odd question here of statutory interpretation and strategic purpose. Right in the board, this is worth emphasizing. This kind of shows the energy of Justice Sotomayor. So when we had the attorneys for SAS making the argument that, basically that any means all, Justice Sotomayor immediately raised the concern that this served as a workaround the Quozo decision that upholds lack of review of institution decision. In other words, what Justice Sotomayor is pointing out is what SAS and other patent owners want is for the IPR to make, the PTAB to make a ruling on all the claims, even the ones that weren't instituted, so that those can be appealed to the Federal Circuit. So it's kind of odd. I mean, I think Justice Sotomayor makes an interesting point that there's something strategic going on here by this reading, and that there's nothing wrong with that, but it does raise some questions about whether the SAS argument is kind of undermining this whole idea of institution, and whether it's really kind of getting around the Supreme Court's decision last year in Quozo that the decision to institute cannot be reviewed. So there's that aspect of this. The other aspect of this is, again, as in the oil state case, this background battle over the role of administrative agencies. And this will come up again in a few slides. Should there be deference to the reasonable agency interpretation of an ambiguous statute under Chevron? So there's a lot of discussion about Chevron. In the Gorsuch nomination, there was some question about whether he would uphold the Supreme Court precedent of Chevron from the 1980s. The Chevron decision, in a nutshell, basically says that a court will be deferential to a reasonable agency interpretation of a statute. But those who criticize Chevron say that it gives too much power to agencies and that courts should take some of that power back by more aggressively reviewing what an agency is doing. And so there is some argument that maybe the court will use this case to review the Chevron decision. I think that's kind of unlikely, but as I'll discuss in a moment, it might use this SAS decision to chip away at Chevron a little bit more. So one of the arguments of SAS, text is clear. The word any, it means any. Context is clear. Any is referring to the claims raised in the petition. Allowing the board to pick and choose claims undermines finality and efficiency of review process. And what this means, and this is kind of I think it's a fairly strong argument, though I don't think it's a winner argument, is that, if you don't have a review of all the claims, then there's certain claims that are just going to be in limbo. You don't know whether they're valid or not. And so that undermines this whole idea that you have this proceeding, the IPR, that can provide some efficiency and finality as to the review process. And of course, the institutional phase, as you see in Quozo, essentially becomes final, precluding review. And then finally, SAS does raise a Chevron argument. Chevron deference not appropriate because agency interpretation is unreasonable. To interpret the word any to mean only the ones that the board chooses to review seems to be inconsistent with what the statute is trying to do. So we look at arguments of the USPTO. The problem that the USPTO raises is if the PTAB only institutes on certain claims, then there isn't a complete record to review by the Federal Circuit. And so even though there might be some efficiencies gained by having the PTAB publish a review of all the claims, that efficiency is really illusory because it's not clear what the record that the PTAB would have to review this. And so once it goes to the Federal Circuit, the patent owner that would be challenging a PTAB decision basically can say that the PTAB decision was faulty because there was no evidence to support it. There wasn't a preponderance or clear and convincing evidence to support the finding of unpatentability. So there's kind of a catch-22 there. It might be saving some costs in having the PTAB review all the claims, but those costs probably would be lost in the actual litigation appellate process. The statute is consistent with the purpose of inter partes review. Nothing prevents partial institution, and this efficiently handles the petition if the board can identify the most problematic claims and then go after those. So, for example, if you have one independent claim and then several dependent claims, and it can basically say that independent claim we think is unpatentable, which then would have some effects on the dependent claims as well. The word any represents facts that some claims may be settled or canceled. So the word any does not necessarily mean all, because during the process of the IPR, some claims may be settled. The parties agree that the claims are fine, or the parties might agree that the claims are not fine. And so settlement is possible upon approval by the PTAB, or the claims might be independently canceled. There might be, for example, a judicial proceeding that's going on simultaneously, or there might be some proceeding with USPTO regarding cancellation. So in short, partial institution offers an efficient approach to reviewing claims that's consistent with the statute. What SAS is proposing, the USPTO would argue, would actually be inefficient. It would be adding costs and not necessarily be consistent with what the IPR proceeding is supposed to do. The assessment. So this basically boils down to a literal reading of the statute versus a purposive reading of the statute. What is the statute intended to do, and is that being upheld versus, well, the language says any means all, therefore we should follow that. This is a standard debate in statutory interpretation. I tend to lean more towards purposive reading. Literal readings, again, literal readings, the problem is the text can be taken out of context. And so I think the purposive reading probably favors the government here. There's deference to Congress based on need for reviewing the patent grant. So that deference issue I mentioned in the context of Oil State comes up here again. And so we'll see what happens. Of course, if Oil State wins, then SAS's appeal becomes moot. So that would be interesting if that's what happens. Because if Oil State wins, that means the IPR is unconstitutional. And so the technical detail that SAS is raising is largely irrelevant if the underlying proceeding is unconstitutional. Finally, requiring complete institutional review of claims seems to take away some discretion of the agency without any a concrete benefit in terms of really having efficiency gains or streamlining of the process. What's my prediction? I think affirmance is likely. As with Quozo, court would create more problems by undoing a statute that seems to generally work. And then how much do you hang on the word any? I would be sorely disappointed if the final decision turns out to be a 30-page opinion on the various meanings of the word any. I'm sure they'll talk about this and probably bring out their dictionary to help us understand what the word any means, but I don't think it's going to hang too much on that word alone. Now, will the court use this to chip away at Chevron? I think the court might say that the statute is ambiguous, but no deference to agency. That's not uncommon. I mean, this whole notion about whether an agency's decision is reasonable is really a flexible standard. I mean, a court might say, well, we find the statute is ambiguous, but the agency is unreasonable. The courts have done that. So, Chevron is an interesting case. I mean, people tout it as saying that it's about the administrative agencies and protection of the administrative agencies, against overreaching by the courts. Chevron is necessary for the balance between the executive branch and the legislative branch, as well as balances between those two branches and the judiciary. But Chevron, in many ways, is a slippery case. It's, as I say here, the fragility of Chevron. And the fragility comes up in how the court determines whether a statute is ambiguous. And it also can come up in terms of how the court will determine whether an agency interpretation is reasonable or not. So we'll see what the court says about Chevron. I don't think it'll overrule Chevron, but I think it might further chip away at the fragile aspects of that decision. So here's some final words. Thanks for your patience. I think this is an important doubleheader. I mean, these cases, again, do raise some fundamental questions, and so it was kind of exciting to have a day. I was not in the States. I would have attended the arguments if I were there. I'm on business now in Tokyo at the Japan Patent Office, and I'll talk about that in a minute for a possible future webinar/webcast. But I did read the oral arguments as they came out, and I heard the oral transcripts. And so it's an exciting case. It raises some important questions, not only about patent law, but it's not just simply for patent nerds. It's also for administrative law nerds and constitutional law nerds as well. So there's a lot of joy to spread around. Here, it's interesting to see how the court, why the court granted cert here. Was it trying to make a point? I think the court is trying to clear the air on the American Invents Act and patent policy. There's been a lot of discussion about these issues, and I don't know if the court definitely has a view one way or the other, except, based upon its precedent, generally about being deferential to Congress. And so I think it granted cert largely to clear the air and to give some sort of process so the various arguments can be heard. I think what the court will try to do is give more active consideration of the details in patent practice. A lot of patent practitioners wonder about the constitutionality of the IPR, wonder about what the PTAB is doing. And so the court might give some consideration about that patent practice and really emphasize that and the importance of this IPR. I mean, there have been some studies, these are obviously, studies that are only about 5 years old, but they show that the costs of litigation, of patent litigation, have gone down quite a bit with the implementation of the IPR. So there's a general sense that the IPRs have been beneficial. Now, of course, the constitutional question is separate, but the court does take a fairly pragmatic approach and is going to be hesitant to find something that's unconstitutional, especially in the business areas. This is not really implicating individual human rights or social rights, such as marriage or civil rights for that matter. So this is largely a business case, and so the court is going to be very hesitant to find things unconstitutional if there seem to be some practical business benefits. So those are my thoughts about this, and thank you for listening. I hope people have found this webcast helpful. Feel free to contact me at the email address that'll be posted below on the YouTube page. And then for future webinars, I think this will be the last webinar for 2017. But in 2018, I want to do a webinar on developments in design protection, so design patents and copyrights. That's what I'm working on here in the JPO during this brief visit. Basically learning a little bit about Japanese design law and how it compares with the U.S. We're also organizing a colloquium at the law school to be held on April 25th on climate change and patent law. Last year we had a separate webinar webcast about this issue, but now we're doing a half-day colloquium on the topic, and I think I'll follow that up with a webinar, and possibly we'll have some audio or other recording of the colloquium itself, and I can provide some details for those who are interested. And I'm hoping to also organize a patent ethics webinar sometime in the spring. So I look forward to communicating with you in the future, and I hope this has been instructive, and I look forward to your feedback. You have a wonderful end to 2017, and all the best for a great 2018. It's been great working with you. Thank you.